Hello, welcome to Legal Action. My name is David Siegel. Today we're going to be talking about the small claims process. I am joined once again by my host, Jesse Barrientes. Jesse, welcome.
Thank you.
How are you this evening?
I'm fantastic. How about yourself, Dave?
Not too bad. You're back from your vacation?
I'm back from vacation, got a little color, and unfortunately ready to work.
Okay, you ready to talk about small claims?
Absolutely.
Okay, let's jump right in. Everybody thinks of small claims as the people's court type of situation where they just appear before a judge, spill out their case, just like they see on daytime TV, and get a quick result. Is that what small claims is all about?
It's a little bit different. Small claims is certainly designed to get you through a decision and a judgment in a quicker amount of time than you would in another case. And we'll see as we talk about it tonight that we have, there's other steps in other cases that are not small claims, that discovery process where there's written interrogatories and written requests to produce and maybe requests to admit, and then there's depositions that people do, which is, after you get all that discovery together, then, you set a deposition, which is in front of a court reporter, and the person or the deponent is sworn, and you ask them questions based upon what they have. Now, that can take a lot of time, a lot of effort, and a lot of money, but the small claims process is designed to kind of streamline that. But to answer your question, no, it's not like you see on television.
Well, a small claims is basically a civil action that's brought in the county in which the parties reside. What type of cases or civil actions are heard in small claims court?
All different kinds of things. Anything from a breach of contract to auto accident, property damage. Maybe you lent me some money and I didn't pay you back. Maybe we have we live together in an apartment. I skipped out on you. A lot of times people are trying to get their money back from a landlord, their security deposit. It covers the whole gambit of cases.
What is the dollar amount or jurisdictional amount that you can sue for?
Well, I believe it was December 6th of 2005. They raised the limit from $5,000 to $10,000 in terms of the limit. Before it was up to $5,000 and that's it, and now it's up to $10,000. And what that did was it of course increased a lot more of the cases for the small claims, but it took a lot away from the collection, from the bigger cases. A lot of the small claims cases too are credit card balances and those kinds of things. So it's really freed up the municipal division, arbitration division, and the law division.
Now, even though small claims doesn't require a person to hire an attorney, would you recommend that a person hire an attorney in a small claims case, or do you suggest that they pursue those waters and try and traverse those waters on their own?
Well, they really should. I mean, if either you're the plaintiff, which means you're suing, or you're the defendant, which means you're the guy or gal being sued. And so it's always good to have the advice of an attorney to check it out. A lot of places will give you a free consultation, so even if you're not going to hire somebody, it can't hurt to try to get some good advice. I always think it's better to have an attorney because obviously they know the system, they have the education, they're familiar with the process, but unfortunately, a lot of times it's just not feasible, financially feasible.
Right. The cost it would take to hire an attorney might exceed the amount you're suing for in small claims.
Yeah, just for an example, let's take a case where someone's trying to get their deposit money back from the landlord. Maybe your deposit is $500, and you go into an attorney. I'm fairly certain that your retainer fee is going to be at least $500. Chances are 3 times as much. And so it's not financially feasible in that way. I've told several people who came, I've counseled them, given them some advice, and basically kind of explained that to them and help walk them through the process so they had a better idea of what to expect and what to do.
Sure. So if someone does seek an attorney, but they're not able to hire one based on the fact that it's just not economically feasible, they still have this anger or this desire to pursue the small claims case.
Mm-hmm.
They're going to bring it themselves, right?
Sure.
What's the first thing they need to do to bring a small claims case?
First thing they need to do is in most of the different counties, they have online forms, and you can, it's very simple. Actually, the statute requires, and I think it's, here it's Supreme Court Rule at 282, it essentially requires just a brief statement of your case, the nature of your claim, the amount that you're asking for.
Handwritten, correct?
It can be handwritten.
Doesn't need to be typed out on
Doesn't need
computer.
to, but it'd be nice if it were legible. And I wanted to talk because my handwriting really isn't all that legible. But it really should be, because you want the judge to be able to read it. And if it's not legible, he's going to have a problem. He's going to be able to, when you do your trial and everything else, to get that out. But it's nice. I mean, I think that appearance counts. But you can get it a lot of times if it's online. You can fill it out online, and so it ends up being typed. And then what's required, along with the nature of the claim and the amount, would be also the telephone number and address of the plaintiff, and an address and telephone number of the defendant, or business address, or employer address, and it's just one page. Also, if you're suing on something that requires a document, let's say it's a breach of contract. Let's say I lent you, or you lent me $50, and I signed you drew a little note and I signed it. That's something, or a copy is required to be attached to the to the complaint, and generally even in the page. And they're not going to show this here, but just the one page form, and it's straightforward, fairly easy. So that's where you would start, and then.
With one page, it's all-inclusive. All the information you need to fill out is on the one page.
Right. You sign it in front of a notary or in front of a clerk. And I would suggest making a few copies for yourself, just so that the original one will go in the court file, and then just so that you have a couple extra copies if you have to hand one up or anything else. Actually, you're going to need more than one copy, because they're going to serve it. Then your next step would then be to go to the clerk of the court, wherever that is, and file your complaint. And pay the fee. And
what are we looking at in terms of fees right now for small claims?
It depends on the money amount. And you
talking a couple $100?
Yeah.
Right now?
Yeah.
Okay.
And then you can also have your option of a jury trial if you want. And if you're the plaintiff, you're required to make the jury demand at the time that you file your complaint. And I believe it's like $12.50 for 6 people and $25 or so, something like that for 12. And if let's say I filed it and I just got a 6-person, and you came in as a defendant, you could pay the other $12.50 and get a 12-person. Or let's say I didn't file a jury demand, but now you come in as a defendant and you want a jury. You can certainly do that by the time that you have to appear.
Let me stop you here. This sounds a little crazy. We're talking about a case where they couldn't hire an attorney
because
the amount of damages was not high enough. They filed it on their own.
Right.
They want to get before the judge for a determination, and someone is actually going to impanel and waste the court's time with a 6 or a 12-person jury?
Well, no, hang on, because it
for
could
$12.50 or $25.
It could be up to the claim could be up to $10,000. So it might not be a little claim or several $1,000s, but we're in America, and those are the rules. You're entitled to have a decision by by jury of your peers.
But typically, what's the reason for a defendant to decide to have a jury appointed on their case?
Well,
what's the reasoning?
The reason is that the jury might be more conservative than the judge would be. It depends on where you're at, but that's the typical reason why people would do that. Now, sometimes plaintiffs think that, hey, listen, I have a really good case, and if the jury heard this, then I would probably get more. So there's different schools of thought. But
well, this show airs heavily in DuPage County. So to put you on the spot, what are the DuPage County jurors like?
They're conservative. They are.
What a shock.
Yeah, it is a little bit shocking. However, the DuPage County judges are excellent, and I'll tell you, if you do a bench trial in front of most, you're going to get a fair shake with respect to your claim.
Yeah, I found that to be the case too in DuPage County. I will agree with you on that. Okay, you filed the complaint. You have to notify the defendant that you have filed this complaint. How do you do that? There's many ways to do this, right?
That's called service of process, and you can have the sheriff serve them, and that would require a fee. And that's typically how you do it in every other case. And you pay the sheriff a fee. The sheriff would serve summons on the individual. Hopefully, if the person's there.
Is that by going to their house, going to their job?
Going to wherever the address you put in there. That's where they're going to go. And if they're not there, then it would get returned perhaps unserved, and you might might have to get what they call a special process server, which is a little bit beyond the small claims process, but essentially it's requesting the court to appoint somebody over the age of 18. Generally, it's a private detective or someone who works in a private detective agency to be able to serve it. And
that person can't be related to any of the parties or the subject matter.
Exactly right. And they go out there for a fee and serve, and sometimes even skip trace if you can't find where the person is. However, they also allow you to do it in small claims, to do it by certified or registered mail.
And the court will do that for you as part of their service, correct?
Right. You pay a fee. It's a minimal fee, and they will send it out certified to the individual. And of course, in order for that to be effective, they have to sign it.
Now, what's the likelihood of somebody actually accepting certified mail that has something from the court?
Well, sometimes people don't look. Sometimes perhaps people are just, maybe it's the teenager who gets the mail who happens to be there, or somebody who doesn't know that the mail comes in, the mailman just says, hey, you got to certify it, just sign it. If people are hiding and trying to avoid the system, then they will avoid it.
Right. Now, in addition to receiving the complaint,
right,
the summons is also going to have some specific information regarding the date, time, and location of the hearing. Is that correct?
Exactly. It's going to tell you all of those things.
And is that the day everything is coming to fruition before the court?
Well, no, that's the day, however, that you have to appear as a defendant.
What if you don't appear?
If you don't appear
as a defendant,
or even as a plaintiff, if you don't
yes,
appear as a plaintiff or defendant, if you're a plaintiff and you don't appear, you risk that your case will be dismissed for warrant of prosecution. DWP is what it is.
Right.
If you're a defendant and you don't appear, you risk getting a default judgment entered against you, which means that you failed to appear even though you were duly served. And so a judgment of default will be entered against you, and generally the relief requested in the complaint will be granted.
The plaintiff, though, would have to prove up and explain the damages in front of the court to get that default judgment for the specific relief, correct?
He'd have to do that if it wasn't verified complaint. It depends on how
verified means it's signed.
It's signed, it's notarized, exactly.
Okay. What about the hearing itself? Let's say both parties show up, they're ready to go, there's animosity. One says they want the security deposit back, the landlord is saying they weren't entitled to it, they left the place in a mess, we had to do all kinds of repairs. What happens next?
Well, a lot of times the judge will ask, depending upon the case, he'll ask the defendant, hey, do you owe this money? And,
and that's an effort to nip it in the bud.
Exactly.
And prevent a prolonged hearing, right, when the person might actually admit I owe the money.
If you owe it, okay, fine, we'll work out a plan. And they'll ask, and so let's assume in this situation that we have this animosity and there's no agreement. Then what will happen is it'll be set for trial. Now, in this particular case, and it's interesting, the landlord would be able to probably file a counterclaim, which is a claim against the plaintiff for something that came out of the nexus of facts that you're in court for. So essentially, hey, I didn't get my security deposit back, is what the plaintiff's saying, and the landlord's saying what you said. You know what? You left the place a mess, and I had to do this and that and everything else, and that's what a security deposit is for. So he, might maybe the amount of the repair and everything else exceed the amount of the security deposit itself, or maybe the tenant skipped out and didn't pay a month's rent or something. So the landlord would be able to counterclaim, and so now you have it's really two claims going on at the same time.
Since this is an informal hearing, a lot of the evidentiary rules and a lot of the court decorum rules are relaxed.
That's correct.
In this scenario, correct?
It is. It's informal. In this particular instance, the judge, is allowed to ask questions, direct exam and cross-examination to kind of dig things out, because generally, what you have in small claims are pro se litigants. Pro se means, they appear by themselves, they're representing themselves. And so the rules are relaxed, because if they weren't, unfortunately, I think it would take a lot of effort, because there's a lot of foundation and a lot of things that really go into a regular case when you're trying to prove it.
So in a typical case where a judge is just an impartial person deciding on certain issues, in a small claims case, the judge can actually be a finder of fact, cross-examine, almost uncover the truth of whether or not, in this particular case, that security deposit was wrongfully withheld or not.
He can, right? Yeah, and he is absolutely the finder of fact, and he can ask those questions. Whereas in a non-small claims case, the judge is just the finder of fact, and his job is to kind of referee and to make rulings on objections and make decisions.
What about the more technical items such as discovery, depositions, written interrogatories, request to admit?
The things that we were talking about earlier.
Are those allowed?
They're not allowed. Well, actually, they're not disallowed, but you can't do them in small claims action unless you have leave of court. And
leave of court is permission, no?
Leave of court is permission from the court. And what you'd have to do is to actually file a motion, and that's how you get things before the court, is with motions. That's how you bring it before, for consideration. And you would do, there may be a reason why you would need to do limited discovery, or you would need to do something like that. And you would actually, in a motion, request from the court permission or leave in order to file your motion to do whatever it is that you sought to do.
But there are two motions that you can do without permission, and that's the 2619 motion,
correct,
which is a motion to dismiss.
Right.
Is that correct?
That's right.
And also a 2-1001 motion.
That's correct.
Okay. Those you don't need any kind of permission. You can try and have the case dismissed on motion.
That's right.
What would that effectively do?
Well, 2619 is a motion to dismiss the claim completely, and there's a whole list.
Being unfounded for one?
Well, there's a whole list. One would be jurisdictional basis,
frivolous,
or the statute of limitations is expired.
However, if it's a written contract and the contract's not attached, would that be something that could cause the item to be thrown out?
That's
under statute of frauds.
That's a possibility. You're getting into a little more complicated area here for small claims. But if you fail to attach your complaint, probably in a small claims action, the judge is going to give you an opportunity, because you're supposed to attach whatever instrument, to your complaint. So, that's something that I'm sure the court would allow.
The judge who sits in small claims, is that a specific type of judge, or is the judge also hearing non-small claims cases at the same time, on the same day, on the same call?
Well, I think typically they hear, because the calls are so big, they would hear the small claims cases. There's a variety of different other kinds of cases, but essentially, and I think in DuPage they have them broken up between, $1 to $5,000, and then from $5,000 to $10,000, but they're all still small claims cases.
So somebody could be mixed in on a pretty heavy day with bigger cases on the call that day, correct?
With other cases, sometimes the judge floats around, but I think for the most part they, take care of their particular call.
Okay. So basically, the judge is going to hear the arguments and render a decision.
That's right.
Now, the judge has a lot of power in terms of not only the dollar amount that's set, but also, surprisingly, in terms of ordering an installment payment plan that cannot exceed 3 years. Is that correct?
Yeah, the judge, unlike a regular case, if the judge finds that, hey, Mr. Landlord, you have to give me my security deposit, and as for the counterclaim that you filed against me, it's there's no validity to it. So he can say, hey, listen, all right, you have to pay this in installments. So $100 a month for the next 5 months. And what happens is the case effectively it's put in an installment order that indicates the case is dismissed with leave to reinstate. So if you miss a payment and you don't pay pursuant to the order, the plaintiff can come back in and what they call vacate that installment order to take it away, hold it for naught, and get you to comply. And the court retains jurisdiction for those purposes.
What are some other methods of collecting on a judgment if the court does not order an installment plan? It just says judgment in favor of the plaintiff for $750 and cost of suit. What does one do to try? The defendant's not going to pull out the checkbook and write a check for that, correct?
No, and that's what a lot of people think that's it. That's their battle. Once they get the judgment, then they're set, and that's not the case at all.
That's often the starting point.
That's the starting point, because then you have to collect on the judgment. If there's not an installment order that's been entered and not an agreement in that way, and that the judge has ordered, then you have to come in on supplementary proceedings, which is generally it starts with the citation to discover assets, which again is another day. You serve it personally on
another day, another document, another service,
another fee. Exactly right.
Another fee.
Exactly. And so what that seeks to do is to have that person come in, and then that person is sworn under oath, and he has to tell you where his or her assets are. Or you can do a wage or non-wage garnishment. A wage garnishment is what it says, a wage garnishment. If you know where that person works, You have to fill out the paperwork, and again, there's a fee.
And there's a learning curve on how to fill out these forms.
Oh yeah, exactly right. And you send it to the employer their interrogatories essentially, and they answer that. And if they have the money, they're required to take out the particular amount of money.
And the non-wage, explain what that is.
Non-wage. Let's say you have a bank account, and I have a judgment for that $500, and I know where your bank account is. So I fill out a non-wage garnishment, and I levy it against the bank. I serve it on the bank. And they answer and they say, yes, we're holding money for you, Mr. Defendant, in the amount of whatever. It'll cover this judgment. And then once you get the answers back, and they have a certain time to respond, they're supposed to send it to the court and copy to you as well. Then once you see what that is, you can go into court and do what they call a turnover order.
I think, let me ask you, the bank will actually hold 2 times the amount of the judgment if those funds are in the account.
Well, I think it depends on the institution, but they want to protect themselves, because if you disobey one of those non-wage garnishments, then who's going to be on the hook for that?
Right.
It's going to be the institution.
It seems like a lot of work. Why would anybody want to go through all these rigors on their own to try and collect less than $1,000 or less than $2,000? How much time are they investing to try and collect it?
You know what? I can tell you why. I can answer that question for you. A lot of times people, and not with just those cases, even with cases that exceed the small claims but are still not financially feasible in the bigger picture. That's because they have principle. And a lot of times, that's what it is. It's not, they say, it's not the money that they care about, but it's the fact that they've been wronged and they want to, justify it. It's not the money. I want to make, this person, understand that he was wrong and just kind of to push it in. Unfortunately, if it's principle, then you're going to end up paying for your principle.
Do you think some of the TV shows that involve court proceedings have increased the amount of people who want to go into small claims court and bring their cause of action and have their quote-unquote say in court?
I think it has, because it's more exposed. People have a different idea on what it is, what really happens, and what's on television, and the kind of antics that go along with it.
I think it's one of those things that when they're finally in it, they realize this is a lot more than I thought it was.
Yeah.
This is a heavy undertaking. It's a lot of time. It's a lot of paperwork. It's a lot of learning. And then you still have to present your case and win it.
You have to present your case and win it, and you're going to have to take off work.
At least once.
At least once. More than likely, it's going to be a couple of times. Which leads to interesting too in terms of small claim court. If a corporation, for example, can't use a small claims process without an attorney, they can't come in as an officer, manager, director.
They can defend, though.
They can defend.
But they can't bring a suit, and they can't file a counterclaim.
And they can't file a counterclaim or anything like that. Unless they hire an attorney.
But they have attorneys, don't they? I mean, they're big
corporations. But there are some small mom-and-pop corporations, some small corporations where there's just one person. And let's face it, lawyers sometimes are expensive.
What would be a typical retainer for a corporation in a small claims case? I couldn't imagine.
Well, I guess it would depend on the case. It would depend on the relationship. There's so many things that go into that. I mean, if you have a client that you represent on many different issues, a lot of times attorneys will do it at reduced fee or even gratis, which is for nothing. Yeah. It just really depends. It depends upon the amount and all that other stuff.
Let's talk about a situation where you actually sue a corporation. They don't defend themselves because of the cost involved.
Right.
It's a $500 cause of action. They're just willing to let the plaintiff get a judgment against them. Can you then bring a citation to discover assets and bring in a corporate director or shareholder and have them disclose where the corporation has their assets? They could be international.
You sure can, but I would think for international, they most likely wouldn't just let it go for $500, because sometimes big corporations, they have attorneys on retainer, and so it's no more or less skin off of their nose for somebody to come in and take care of it. And it's important for people to know that it's not going to go away if you put your head in the ground. Okay, if you ignore it, it's not going to go away. It's just going to be worse. You have to address those things head on. I mean, that's just the way it is. If you ignore it, then what's going to happen is you're going to get a default judgment, and things, probably won't go well for you.
I would be remiss if I didn't ask you about the time frame that it takes to bring a cause of action and then appear before the judge to have it heard. If everything goes smoothly, what kind of time frame are we looking at here for small claims?
If everything goes smooth, I think once you get in, it's usually it's within, when you file your complaints, within 14 to 46 days or so, the appearance date, and then you get into court, and then they set it. Depends upon the court's docket. It depends upon whether or not it is a jury trial, because those obviously are more involved, and so it's going to be a time when the court has more time to deal with that.
Is it safe to say we're talking about a 2 to 4 month process, possibly?
Yeah, I think that would be fair. I think that would be absolutely fair to say. I mean,
and if there's a jury, quite a bit longer, possibly?
It may be longer, but probably the same kind of time frame, because they can, have those schedule it out.
I just can't imagine a jury being impaneled, and the jurors come in, they sit in the box, and the opening statement comes up, and it's Joe Pro Se litigant, and he's complaining about his security deposit not being returned. I just can't imagine what these jurors who had to take off work for their $17.10, whatever the stipend is now for jurors. I just can't imagine this scene. It almost seems surreal.
Well, the jurors have to be there anyway. They're not there for that specific case.
But that's the one that they got picked for.
That's the one they got picked for. But they're there. We all, everybody has to do their civic duty, and so you go in, and it's not that case. It could be a criminal case. It could be a murder case.
Right.
It could be a bigger case. I would be happy if it were a small claims case, because guess what? I'm only going to be there for that one day, because it's going to be over. If you're in for a different case, a bigger case, guess what? You have to keep on coming back until that particular trial is over. So you may find that you're there for a week, a month, and goodness,
you may be sequestered.
I mean,
in
a criminal case, it certainly is possible. And that means, sequestered means, for the folks at home, just means that you're not allowed to leave.
Right.
And so they put you up in a hotel. And
any final tips of advice for someone who's thinking about filing a small claims case?
It can be done. You can do it. They can absolutely go and look online, look at the forums. There's a law library that's free to people. But I would also, I would consider talking to an attorney. I would consider retaining an attorney. Again, it really depends upon the amount of the claim. Because if it's a $500 claim, I'd be reluctant to do it, because it's just not worth the kind of time that's involved. However, as I said, I have walked people through the situation, the process, and told them what they needed to do. Obviously not charged for that, just to try to kind of help them out. And so it can be done. I would think that, hey, you know what? There's a peace of mind that comes with not having to worry about anything, not having to worry about taking off, not having the anxiety, the anxious feelings that you would have in any litigation.
Right. There's always the unknowns in litigation, too. For all you know, not only are you going to lose your case, but if the other side files a counterclaim like you mentioned earlier,
that's correct,
or if the court finds that you filed a frivolous action just to harass or to make a point that you didn't have one, you might actually wind up having to pay the other side.
That's absolutely true.
That seems very risky.
It does. I mean, so be sure that what you're claiming is certainly legitimate.
Yeah, my father gave me some advice that I'll pass along to you as well.
Excellent.
And the advice goes like this: your first loss is your best loss. So if the landlord owes you $500, you may be best just taking that loss and not trying to recover it, because you'll have to outlay court costs, sheriff's fees, time, energy. It just seems to be possibly your first loss is your best loss in these kind of small claims cases.
That's some good advice. Just really quickly, if you are successful, you will be able to get your costs back, but again, you have to collect them.
Okay. Well, I think we found some valuable information from Jesse Barrientos regarding small claims. Thanks for joining us. We'll see you next time on Legal Action.